All right. Members, let's get settled in. Is everybody punched in? And Madam Clerk, if you'd open the board for roll, please. We're just picking up on our Judiciary Committee from Monday. Appreciate everyone being here. Madam Clerk, take the roll, please.
Mr. Chair, you have 15 members present. You have a quorum.
Very good. Members, any personal orders or announcements before we get started? Representative Salinas, you're recognized.
No, I was just
Okay, very good. All right, you're here. Chairman Doggett, sir.
Thank you, Mr. Chairman. I have a shadow, not behind me, but in front of me today somewhere, and I hope I didn't lose her. There she is, Addison Collins from Stewart County High School. And thank you for coming.
And Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. I also have a shadow today, Glory Malone. She's also from Stewart County High School, and let's make her a welcome. Let's let them know we appreciate it when they come to visit us. So, yeah.
We do. Chairman Bolso, you're recognized.
Thank you, Mr. Chairman. Just to make it a trifecta, I also have a shadow, a young man, Brigham Page from Stewart County High School. Please make him welcome as well.
Members, anyone else? I have a shadow, members. His name is Ethan Smith, and he is also from Stewart County, and he's here with us today, doing a wonderful job. All right, members, anyone else? Any additional shadows? Seeing none. Very good. We have a calendar. Members, folks, we're going to be jumping around trying to get through some bills that we know we can get through today. We're going to start without objection with item 9, House Bill 2188 by Chair Lady Littleton. You got a motion in a second. I'm looking at House Amendment 13741. Motion. You got a motion in a second. Is that something you want to go ahead and adopt?
Yes, please.
All right, members, you've heard it. Any objection? All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back in the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman. This bill, as amended, requires the Department of Children's Services to collaborate with the Department of Disability and Aging to ensure the children in the state custody or at risk of coming into state custody and who have intellectual or developmental disabilities receive appropriate services and supports. Authorizes the Department of Disability and Aging to develop training for DCS related to identification of and supports for the child with a disability and to provide consultation on oversight tools and monitoring or residential services for children with a disability. Authorizes DCS to refer children suspected to have intellectual or developmental disability to the Department of Disability and Aging for service recommendations. And it also requires DCS to submit a report outlining its compliance with this legislation on January 1st, 2027.
Very good. Members, you've heard the explanation. Any questions for the sponsor? Seeing none. Any objection to the question? Seeing none. Madam Clerk, you'd open the board. Members will be voting to send House Bill 2188 as amended to calendar rules. All in favor, vote aye. Opposed, vote no. Is there a member voting? Any members change their vote? Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 2188 as amended is moving to calendar and rules. And that brings us to item 10. That's House Bill 2350.
second.
By Chair Lady Littleton. I'm not seeing an amendment, ma'am. You're properly recognized.
Thank you, Mr. Chairman. This bill requires the Department of Children's Services to provide a copy of a petition of termination of parental rights or guardianship rights to a foster parent within 7 days of the filing of service of the document if the foster parent has served as the physical placement for the child for at least 9 consecutive months and requires the foster parent maintain such a petition as confidential information.
Very good. Members, you've heard the explanation. Any questions for the sponsor? Seeing none. Any objection to the question? Seeing none. Madam Clerk, you'd open the board. Members will be voting to send House Bill 2350 to calendar and rules. All in favor, vote aye. Opposed, vote no. Is there a member voting? Any members change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 1 no, and 1 present not voting.
Very good. Members, House Bill 2350 is moving to calendar and rules. That brings us to item 11. That is House Bill 2352. Second. You got a motion and a second. Members, I'm looking at House Amendment 14201.
Motion. Second.
We got a motion and a second. Shirley, is that something you'd like to move forward with?
Yes, please.
All right, members, you've heard it. Any objection? All right, seeing none, all those in favor vote aye. Aye. Opposed, vote no. Ayes have it. Now we're back on the bill as amended. Shirley Littleton, you're recognized.
Thank you, Mr. Chairman. This bill as amended requires each juvenile court to report to the administrative office of the courts each new dependency and neglect case along with supporting information on a monthly basis.
Very good, members. You've heard the explanation. Any questions for the sponsor? Representative Johnson, you're recognized.
Thank you. Well, what is the goal here for this piece of legislation?
Shirley Littleton.
Thank you, Mr. Chairman. Currently requires each juvenile court to report to the AOC each new delinquent case or unruly case in which a child is charged, along with the supporting information on a monthly basis. Therefore, the juvenile courts will be able to report the additional information as put forth in the proposed legislation by utilizing existing staff and resources.
Okay, does this change any of like the access to any of these records? Is it opening the records at all?
Shirley Littleton, you're recognized.
Thank you, Mr. Chairman. No.
Thank you.
Very good. Members, you've heard those questions. Any additional questions? Seeing none, any objections to the question? All right, seeing none. Members, all those in favor of sending House Bill, Madam Clerk, you open the board. Members, all those in favor of sending House Bill 2352 as amended to calendar rules, vote aye. Those opposed, vote no. Has every member voted? Any member wish to change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 0 noes, and 1 present not voting.
Very good. Members, House Bill 2352 is moving, as amended, is moving to calendar and rules. Very good. Members, if we could move down the calendar without objection to item 94. That's Representative Alexander, House Bill 2126. And Representative Alexander, I'm looking at two amendments. One is, the latest one is 16068, and then.
That's correct.
And then, so you got a motion and a second, but I'm also looking at 13107.
That is correct.
Okay, let's start there, members. Let me ask this. We have a motion and a second on House Amendment 13107. Members, we want to go ahead and adopt that amendment. Any objection? Okay, all those in favor say aye.
Aye.
Opposed, vote, say no. Ayes have it. Now we've adopted 13107 to House Bill 2126. Now let's look at House Amendment 16068, and that may have been filed by Leader Lamberth. Okay, you got a motion, a second. Members, do we want to go ahead and adopt this amendment? Any objection? Seeing none, all in favor say aye. Aye. Opposed, say no. Ayes have it. And without objection, we're going to roll both amendments into one. And we're back on the bill as amended, and you're probably recognized.
Thank you, Chairman, and thank you, committee. This bill came about because I had a constituent in my area who had property, and on that property, there was an encampment that resulted in property damage. Our constituent was on the hook for thousands of dollars of repairs to his damaged property. What this bill does, it creates an aggravated criminal trespassing charge for the following: engages in camping on private property that they do not have consent and should reasonably know that they do not have consent to be on, which means there has to be some type of signage on the property. As a result of the camping, the property is damaged, vandalized, defaced, or littered upon. The sentencing would be violation of aggravated criminal trespassing. Criminal trespassing is a Class A misdemeanor. If found, the property owner has incurred expenses to clean or repair the damage caused by the aggravated criminal trespassing. The defendant must be punished by the following mandatory minimum periods of confinement at 100%. First offense, not less than 30 days. Second and subsequent offense, no less than 60 days. This allows for a person to be sentenced to participate also in a drug or a recovery court program that is certified by the Department of Mental Health and Substance Abuse or another licensed treatment program. And in addition to any penalty, the court may require the defendant to clean or repair the damage to the private property that resulted from the offense. A property owner who is a victim of aggravated criminal trespassing is not liable to a political subdivision of the state or agency with a political subdivision for the cost or cleaning of the repairs required by the result of the offense. The court may require cost and cleaning of the repairs be paid by the defendant as the restitution. Does not establish a duty for any political subdivision or agency associated to clean or repair the private property. With that, I'll stand for questions.
Members, you've heard the explanation. Any questions for the sponsor? Representative Johnson, you're recognized.
Thank you, Mr. Chair. I guess my concern here is littering is in the same category as vandalism and property damage. So does that concern you at all that something that could be minor littering is considered in the same light as vandalism and property damage?
Representative Alexander, you're recognized, ma'am.
Well, if someone comes on your property without your permission and they litter on that property, it shouldn't be the owner of that property's responsibility to pick all that up.
Yes, I understand that, but there's a broad range of what that littering could be, and I guess that's what concerns me.
Okay.
All right, very good. Any additional questions? All right, seeing none, any objection to the question? All right, seeing none, Madam Clerk, will you open the board? Members, we're going to be voting to send House Bill 2126 as amended to Finance, Ways and Means. All those in favor vote aye, opposed vote no. Is there a member voted? Any member wish to change their vote? Madam Clerk, you take the vote.
Mr. Chair, you have 14 ayes, 0 noes, and 3 present not voting.
Very good. Members, House Bill 2126 as amended is moving to Finance, Ways and Means. And just a couple of housekeeping issues. I should have announced this earlier. Item 13, moving back to item 13, that's House Bill 1814, has asked to be taken off notice by the sponsor. Is that correct, Chairman Russell? Very good. So without objection, House Bill 1814 will be taken off notice. And that brings us down to, let's move down to item 21. That's House Bill 315 by Chairman Bolso. So you've got a motion and a second. Looks like I'm looking at House Amendment 13774. Is that something you'd like to proceed with? Okay, members, without objection, we're going to roll item 21, House Bill 315 to the hill of this calendar. Members, without objection, let's move to item 74. Be Representative Slater, sir. I see you sitting there. You got a motion and a second. I'm looking at two amendments, sir. I have one is House Amendment 4654, and also I have a newer amendment, 15725.
Thank you, Mr. Chairman, and we'd like to go with 015725.
All right, members, you've heard it. Do I have a motion and a second? Very good. Do we go ahead? Any objection to adopting House Amendment 15725 to House Bill 1263? All right, seeing none, all those in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended. You're probably recognized.
Thank you, Mr. Chairman, and thank you, committee. And I'd like to just take a brief couple of minutes, maybe to share a personal story that is somewhat related to what we're addressing today, which is voluntary surrender of parental rights. We have 2 of our grandchildren that came into our family, one through foster care and then adoption, and then one through voluntary surrender of parental rights. As it turns out, the first time that I ever saw our granddaughter was in a parking lot. And the mother of our granddaughter had contacted our oldest son and his wife just 24 hours before. We scrambled and got everything in order. The mother traveled from out of state and met us in a parking lot and literally just simply handed over our granddaughter. She did not want to go to court. It was obvious. This was the 7th of her children. And she had been in quite a bit of trouble. We're very thankful for the fact that no matter her decisions, she made the right decision when it came to, as it turns out, one of our grandsons and a granddaughter. And so this bill is related to the voluntary surrender of parental rights. This proposal provides the exclusive procedure for the voluntary surrender of parental rights for a surrendering parent who does not want to appear before a judge while preserving judicial oversight. With that brief explanation, I stand ready for questions.
And thank you for that explanation, Representative Slater. Representative Johnson, you recognize.
Yes. How does it preserve judicial oversight? I mean, I have these scenarios in my head of maybe you're turning them over to a family member who is not the best person to be turning this baby over to. So it sends off all sorts of alarm bells in my head.
Representative Slater, you recognize.
Thank you, Mr. Chairman, and thank you for that question because aside from that story, which was not completely what this bill addresses, but we have experienced this. Let me point out to you how that is preserved, how judicial oversight is preserved. And Mr. Chairman, if for some reason I'm not able to answer directly from here, then I think that there maybe is somebody else that would be able to dig a little bit deeper. But I think looking at the amendment, we can see how judicial surrender and judicial oversight is preserved. On the first page of the amendment underneath, down at the last section, the child being surrendered is 6 months of age or less. So it's not any child. It's a child who is 6 months of age or less. The child being surrendered is not in the custody of the department. So this has nothing to do with those that are in DCS custody. The surrendering party is over 18 years of age at the time of surrender and represented by an attorney. So there has to be an attorney that is involved with the surrendering party or with that surrendering parent. Continuing on page 2, the notice must be signed by the birth parent, the attorney representing the birth parent, the accepting party, which may be the prospective adoptive parent or a licensed child placing agency, and an attorney representing the accepting party. So this outlines that there is counsel that is involved. So officers of the court are involved every step along the way. There is then a hearing, and that we find on page number 4. At the hearing on the notice, the court shall review the executed notice, the court report based upon the home study, the surrendering party's pre-surrender information form, and the accepting party's pre-acceptance information form as applicable, and determine whether the documents comply with this section and whether the notice is knowing, voluntary, and in the best interest of the child. So all of this documentation that involves an officer of the court, attorneys all along the way, then is presented to the court in a hearing, and that's when a judge will make a final ruling. And so that's why, or that's how the judicial surrender is overseen by the court.
Okay, thank you. So, and that takes place before they get the child.
Representative Slater, you recognize, sir.
Thank you. And yes, that is correct. In my illustration, which was a personal illustration, was a different circumstance. And it wasn't that child was adopted that day. There was temporary custody, that type of a thing.
Okay.
But yes.
Okay. So, and the home study does take place.
Representative Slater, thank you.
Yes, that is correct.
Thanks so much.
All right, members, any additional questions for our sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, if you'd open the board for voting. Members, we're going to be voting to send House Bill 1263 as amended to calendar and rules. All those in favor vote aye, opposed vote no. Has everyone voted? Anyone with change vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 1263 as amended is moving to calendar and rules.
Thank you, Chairman and committee.
Just a couple more housekeeping issues as we're moving along. Item 34, that's House Bill 2035. It's been asked to be taken off notice. So the objection, House Bill 2035, item 34, at the Hill of today's calendar is taken off notice. And also item 46, that's House Bill 1734. That's also been asked to be taken off notice. So it's item 46, House Bill 1734 has been asked and taken off notice. Any objection? All right, seeing none. And then members, if we could move to item 47, that's House Bill 2272 by Chairman Crawford. You've got a motion and a second, sir, and I'm looking at two amendments. The latest one's 15772. The other one is, or the earlier one is 15386.
The one I'd like to run is 05772.
Okay, so 015772 members. So
It
you got a
does make the
motion.
bill.
It makes the bill. You've got a motion and a second. Members, we're going to go ahead and adopt this amendment. Any objection? All right, seeing none, all those in favor say aye. Aye, opposed, say no. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. Thank you, committee. I will be brief. This is known as the Dolly Parton bill. What we're doing here is kind of the best way I can describe it. It's like a NIL deal. What we're doing is we're taking the name of the celebrity and they want to bottle of wine under that name or whatever. They're just using the name to sell the wine. She has no interest in distilling it, anything like that. It's just her name. And we have had some issues in the past, so this bill clarifies it. It says this bill clarifies that celebrities such as Dolly Parton can continue to market Dolly wine when the brand is placed in a trust created for three-tier alcohol purposes. Dolly's team worked with the Tennessee ABC system and the wine and spirits wholesalers on this language, and all parties are in agreement. I'll be glad to answer any questions about it, but that's basically.
Well, thank you for that explanation. Chairman Doggett, you're recognized.
Thank you, Mr. Chairman. I was wondering if she was here to testify. Is this something that she's in support of?
She's up in my office. I'll have to see if she wants to come down.
All right, members. Any additional questions? Any objection to the question? Madam Clerk, if you'd open the board, members are going to be voting to send House Bill 2272 as amended to calendar and rules. All those in favor vote aye, opposed vote no. Is that member voted? Member, which change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 0 noes, and 3 present not voting.
Very good. Members, House Bill 2272 as amended is moving to calendar and rules.
Thank you, Chairman. Thank you, committee.
All right, members, we could move to item 48, very next item. That's House Bill 2251, Chairman Grills. And Mr. Chairman, I don't see any amendments on this piece of legislation, so you are properly recognized.
Thank you, Mr. Chairman. This creates a pilot project to provide criminal magistrates in the 10 counties with the largest criminal court experience caseload. It authorizes, if authorized by the legislative body of an eligible county and the judges within the county of that criminal jurisdiction. That judge in that criminal jurisdiction, they will be the ones who appoint that magistrate.
Very good. Members, you've heard the explanation. Any questions for the sponsor? Seeing none, any objection to the question? All right, seeing none. Madam Clerk, if you'd open the board. Members will be voting to send House Bill 2251 to Finance, Ways and Means. All those in favor vote aye. Opposed vote no. Has every member voted? Any member wish to change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 17 ayes, 0 noes, and 3 present not voting.
Very good. Members, House Bill 2251 is moving to Finance, Ways and Means. So if you'll just stay right there, I believe you also have item 70. Members without objection, we'll move to item 70. That's House Bill 1980. You've got a motion and a second, and there's also, I'm not seeing any amendments on this either, so you're probably recognized.
Thank you, Mr. Chairman. This bill, if someone violates condition of a bail, the judge can hold them for up to 10 days.
All right, members, you've heard the explanation. Any questions for the sponsor? Any objection to the question? I see Leader Lambert, sir, you're recognized.
Just want to make sure, I mean, nothing in this bill would preclude a judge from being able to revoke someone's bond or increase the bond or add additional criteria to the bond beyond the 10 days, correct?
That's correct.
All right, just want to get that on record. Thank you.
Very good. Think of that question. Members, any additional questions? Any objection to the question being called? Seeing none, Madam Clerk, if you open the board, members are going to be voting to send House Bill 1980 to Finance, Ways and Means. All those in favor vote aye. Opposed vote no. Has every member voted? Any member wish to change their vote? All right, Madam Clerk, you take a vote.
Mr. Chair, you have 16 ayes, 0 noes, and 4 present not voting.
Very good. House Bill 1980 is moving to Finance, Ways and Means. All right, members, we'll just back up a few spots. If we'll move to item 66, that's House Bill 2101 by Chairman Faison. You got a motion and a second to look at the House Amendment 15433, sir.
That's good.
Very good,
That's
members.
one I have.
Do I have a motion and a second? Members, we'll go ahead and adopt this amendment. Any objection? All right, seeing none, all those in favor vote aye, or say aye. Aye. Opposed, say no. Ayes have it. All right, we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chair. Committee, it's so good to be with you. Many of you know that we are living in a society where just about everything you want can be delivered to you at your house. We're also living in a society that people are able to, through the Choices program, and just because people are healthier, they're able to stay at home a lot longer and not go to a nursing home, which is wonderful. I'm hoping by the time we get where I get old that I can just stay at the house the whole time and die at the house and not a nursing home. That being said, Mr. Chair and Committee, this bill is simple. We're just making it to where people who want to get Sudafed can do it online and have it brought to their house and not have to go all the way to the drugstore to get Sudafed. We have some of the stricter Sudafed laws in America. And I think if we really put down brass tacks, we'd realize that most of our meth problems are not coming from Tennessee, but from somewhere else. So we've worked with our Sheriff's Association, Department of Safety, and they're pretty comfortable with what we're doing. And we're trying to make it easier for some of the people that you and I both love to be able to stay home and order Sudafed.
Very good, members. You've heard that explanation. Any questions for Chairman Faison? All right, Vice Chair Davis, you're recognized.
Thank you, Mr. Chairman. Excuse me, I'm sorry, I'm trying to get sick, so I apologize for my voice. But one of the things that I read about your bill, excuse me, is the tracking system, that's still in place. And so I appreciate that. I know I probably need some. But I just want to say thank you very much for keeping that in place, because methamphetamine was and still is a very destructive narcotic. And we just had an arrest made here in Nashville with regard to a bunch of meth. So I appreciate the fact that you're wanting to bring that convenience to people that are utilizing it in the proper way, but also protecting all of the law enforcement and their concerns with regard to people that want to use this medication in an illicit way. So thank you very much for doing that.
Very good. Members, any additional questions for the sponsor? All right, seeing none, any objection to the question? All right, seeing none, Madam Clerk, if you'd open the board for voting. Members, we'll be voting to send House Bill 2101 as amended to health. All in favor vote aye, opposed vote no. Has everyone voted? Any members change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good, members. House Bill 2101 is moving to health.
Thank you.
If we could move to item 54, that's House Joint Resolution 805. Ma'am, you got a motion in a second. You're probably recognized. I'm not seeing any amendments.
Thank you, Mr. Chairman. There's no amendments. HJR 805 proposes amending Article 6, Section 4 of the Constitution of Tennessee to require judges of the circuit, chancery, and other inferior courts to be residents of a county of their respective circuit or district, rather than residents of the circuit or district, the city to which that judge is to be assigned for 1 year prior to election. In 2025, the General Assembly approved House Bill 490, Public Chapter 487, which established that the residency requirement for a municipal judge with concurrent general sessions jurisdiction, as ruled in McNabb versus Harrison, would apply prospectively beginning at the next regularly scheduled election, which would be 2030. There are currently 27 municipalities across the state of Tennessee who have city courts with concurrent general sessions jurisdiction. The problem is that several of these municipalities are very small and do not have licensed attorneys residing within their city limits. This puts significant stress on the county general sessions court, who must absorb all criminal cases from the municipal court. This defeats the whole purpose for having municipal courts with concurrent general sessions jurisdiction, because they help alleviate the caseload for county general sessions courts. HJR 805 will alleviate these issues by allowing the judge to reside in the county and not just the circuit or district, the city. With that explanation, I stand for questions.
All right, members, you heard that explanation. Any questions for the sponsor? All right, seeing that, any objection to the question? Seeing none. Members, we're going to be voting to send, Madam Clerk, you'd open the board. Members, we'll be voting to send House Joint Resolution 805 to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has there been voted? Any members change their vote? Very good. Madam Clerk, you take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good. House Joint Resolutions moving on to Finance. House Joint Resolution 805 is moving on to Finance, Ways and Means. Thank you.
Thank you, Mr. Chairman and committee.
All right, members, and without objection, we're going to move into item 41, House Bill 1971. I'm going to pass the gavel down.
All right, Chairman Farmer, I'm seeing that there's an amendment 014939.
It is 14939. That is correct.
All those in favor of adding amendment 014939 to House Bill 1971, please say aye. Aye. All those against, say no. All right, it's added to your bill. Sir, you're recognized.
Very good. Members, what this bill does, this brings the law back to the way it was prior to 2018. The General Assembly changed the law and inadvertently allowed for folks to be able to sue the state and other entities for policy disagreements and not substantive disagreements on the law that without any damages. The best way I can put it is, as I said in subcommittee, the best example I can give is if a person is hit by a truck traveling down the interstate and breaks every bone in their body, they have damages. If you're driving down the road and a big truck, a big wheeler, big rig drives by you and you can feel the wind off it, it doesn't hit you, you can't sue that person because you don't have damages. So what this is doing, this is restoring the law to the way it was prior to 2018. So members, with that explanation, I'll be ready to stand for any questions. And I believe we have some testimony as well.
Yes, thank you, Chairman. I'd like to call up, we've got Richard Archie, John Gentry, Matt Rice with the Attorney General's office, and then also Cody Brandon with the Attorney General's office. So if you're here, please come forward. Okay. All right, members, we're going to go out of session to hear this testimony. Where's the Attorney General? Okay. Mr. Gentry, would you like to go first? You've got 2 minutes. I'm over here. Yes, John Gentry.
This on?
Yes,
Yep.
sir.
All right, so my name's John Gentry. Members of the committee, the Constitution is supposed to protect people before they're harmed by government, not after. And this bill reverses that principle. And what Chairman Farmer is talking about, harm, that's called the standing doctrine that the courts use. And the standing doctrine is not law. The standing doctrine is a judge-developed legal doctrine. And so when the legislature says, well, we're gonna let judges go ahead and make the law, that you have to suffer harm before you can bring a lawsuit. And I think that's wrong with the standing doctrine. It's used very often by the courts to wrongfully dismiss cases. Under the Tennessee Constitution, Article 1, Section 1, the people have a right to reform government. Is a government who has enacted unconstitutional law in need of reform? Of course it is. And does Article 1, Section 1 say there must be harm? It does not. Article 1, Section 2, the doctrine of non-resistance is absurd. It is absurd of citizens to not resist arbitrary abuse of power with government enacting law that is unconstitutional. Under Article 1, Section 17, suits may be brought against the state. It is a constitutional right under the Constitution of this state. Article 1, Section 23, citizens have a right to apply to those invested with the powers of government for proper purpose by address or remonstrance. Does Section 23 say we have to suffer harm before we can apply to government? It does not. Does Section 23 say we can apply to those invested with the powers of government? Yes. Is a court invested with the powers of government? Yes, it is. So this
Mr.
law
Gentry.
itself.
Sir. Your 2 minutes are up, sir. Thank you. All right. Mr. Rice?
Thank you, Vice Chairman. I guess a couple points in response to some of the remarks that we just heard.
Mr. Rice, would you care to introduce yourself for the record, please?
I'm so sorry.
That's all right.
My name
Thank
is
you.
Matt Rice. I'm with the Attorney General's office. I'm the Solicitor General of Tennessee. Thank you all for having me. Just a couple of points of clarification with respect to my friend's comments on the other side. My friend seems to be taking issue with the standing doctrine. The standing doctrine stems from the Tennessee Constitution. Legislation can't change the Tennessee Constitution. So this bill has absolutely nothing to do with standing. Standing stems from the Constitution, not from statute. So while my friend may take issue with the Tennessee Constitution's requirements, that is not before this body at this point. Another clarification, it is absolutely false that under this bill, people would not be able to vindicate their constitutional rights and bring a pre-enforcement challenge. I think a little bit of context is helpful for where this statute kind of fits in. This statute was not enacted until 2018. A number, as this body knows, a number of constitutional challenges were raised before this statute existed in that pre-2018 regime. What this statute does is return the law to that 2018 regime and essentially prevent what are effectively policy disputes with the laws passed by this body. It would require, under the Supreme Court's Colonial Pipeline decision, it would require a person to actually have their rights implicated by some governmental actor, rather than just kind of picking out a law in the books that they don't like. And so I do think there's a lot of confusion with respect to what this law is doing. It is essentially ensuring that the parties who bring suit actually have their rights implicated, rather than just have a policy disagreement. And I think that the amendment to the law makes that absolutely clear, and clarifies that this section does not limit any other cause of action or waiver of sovereign immunity to vindicate rights under the Tennessee Constitution or the United States Constitution. I think it is extremely plain that that this is in no way putting the government above reproach.
Thank you, sir. I appreciate that. Representative Kiesling, were you wanting to ask a question? Well, you're recognized,
Yes,
sir.
thank you, Madam Chair. Matt, potentially, I got one quick question here now. Potentially, does this shift power away from our local governments? Could any way, shape, form, or fashion? Could it? Just yes or no?
No.
No, it cannot. All right. Thank you very much. Thank you, Madam Chair.
Representative Bolzo, you're recognized.
Thank you, Madam Chair, and thank you, General Rice, for being here. And first, let me thank you for the tremendous service that you provide every day to our state. We are so lucky to have you in that role. I have two questions for you. The first dealing with sovereign immunity, and the second dealing with the term affected person. First, dealing with sovereign immunity, is it correct that our state Supreme Court has determined that 1-3-121 has affected a waiver of sovereign immunity by the state and its political subdivisions, and that this bill, HB 1971, if passed, will return to the state immunity that was previously waived?
I think it will return it, but not to the extent that Colonial Pipeline still exists. And so Colonial Pipeline is essentially the state equivalent to, in the federal courts, what is the Ex parte Young doctrine. Now, this went beyond Colonial Pipeline, 1-3-121 did, and I think by the alteration to the underlying statute here would return us to the Colonial Pipeline framework. And I think that has essentially two differences from the waiver of sovereign immunity that we see here. The first difference is under 1-3-121, lower courts have held that the state writ large can be held or can be brought in as a defendant. Now, typically you have to sue the specific state official that is actually enforcing the law. Now courts are saying, well, this says you can sue the state. And the effect of that is in discovery, we are getting essentially buried with requests for documents from all state actors. So instead of, for example, a district attorney, you could sue a district attorney in your district to not enforce this statute against you. And instead of having to find documents from that district attorney, we're having to search for documents throughout all types of different state officials. And I can give you an example. In a recent litigation regarding the abortion medical necessity exception, we were asked to turn over the emails of this body and the communications of this body because they wanted to know what was going on behind the scenes and why this abortion bill was passed. We fortunately lost at the trial court. We got interlocutory appeal granted, and they withdrew that request. But under this, I think this body should be prepared to have every law that's passed. They're going to challenge the underlying reason for why that law is passed, and they are going to come after the documents of this body. The second difference between 13121 and the Colonial Pipeline is that it requires you, as I mentioned, to sue the governmental actor that is enforcing the law. You can't just sue the state writ large. You have to actually have some actor that is attempting, or that there's a credible threat. That's all that's required, is a credible threat of enforcement. And you can bring suit under the Colonial Pipeline Doctrine. And it's been done for decades. I mean, it was done until 2018. We have scores of constitutional cases in the Tennessee Reporter prior to the enactment of this law.
Understood, but as the statute currently stands, an affected person could bring an action against the state writ large. But if we adopt HB 1971, that will no longer be true. Is that correct?
I don't agree with that. I guess it depends on what you mean by an affected person, but I think affected person could bring a suit under Colonial Pipeline against the specific state official that is charged with enforcing the law.
Yes, but Colonial Pipeline is the state equivalent to the federal ex parte Young, in which case you can bring an action against a state official prospectively to enjoin the enforcement of an unconstitutional statute, but you cannot bring a case directly against the state under Colonial Pipeline. Isn't that correct?
That's correct. Under Colonial Pipeline, you have to sue the actual state official that is charged with enforcing the law. You don't just get to name the state writ large.
And then the second question I had for you, General, was the issue about affected person. Obviously, 1-3-121 provides this cause of action to what's defined as an affected person, which is an identical term to what we see in the Declaratory Judgment Act that's been obviously in effect now for decades. So isn't it the case that having the requirement that an affected person bring the cause of action deals with this concept that anyone out of the blue can just file a case against the state under 1-3-121, because the person has to show that he has rights or status or legal relations that are affected by the statute at issue?
In theory, yes. In practice, it hasn't been interpreted that way.
Thank you,
but in theory, yes.
Thank you, Mr. Chairman. Thank you, General.
Representative Johnson, you're recognized.
Thank you, Madam Chair. So to Mr. Gentry, in the description of this bill right underneath, it says, as introduced, removes the right of a cause of action for any affected person who seeks declaratory and injunctive relief in any action brought regarding the legality or constitutionality of a state governmental action. When I see something that says removes the right to a cause of action, I find that concerning. Is that something that concerns you with this bill as well?
Absolutely, Representative Johnson, you should be concerned. So seeking declaratory judgment is asking a court to declare a statute as unconstitutional. And so they're saying the citizens can't challenge that. And that goes against the principle that we have a right to reform government and we have a right to apply to government. It doesn't say that we have to suffer harm. And the gentleman for the state here has said that the Tennessee Constitution includes the standing doctrine. I actually authored a book explaining the Tennessee Constitution focused on the Declaration of Rights, but in other parts of it, I have not seen that. And I would like to see how the Constitution is interpreted to say that the standing doctrine is part of our Constitution, because I don't think that it is. That it should raise serious concerns that we can't bring a cause of action already, and I say it with hesitation, but quite frankly, these houses make a mockery of the right of citizens to petition the legislature. We should be able to come to the legislative houses and address the legislative body and say, we think this law is unconstitutional. And so that constitutional right that we have that is fundamental to a government Republican in character, we don't have that right to petition the legislature and address the body and complain that something is unconstitutional. And so now it seems that we want to take away the opportunity to even go to the courts. And so now we have to wait until somebody suffers, until somebody is harmed, that they get prosecuted. Maybe they have to place bail before they can challenge it. And then when they do challenge the constitutionality of a law in court, I believe it is Tennessee Code and TCA 2914-107B, that if you challenge a statute as unconstitutional, you have to notice the Office of Attorney General. And if you fail to notice the AG, the court says, well, you didn't follow the rule, you didn't notice the Attorney General, and so this issue is moot. We're not even going to address the question as to the constitution of this statute that you may be prosecuted under or may have suffered harm for. And that is not an appealable issue. So if you don't notice the AG when you challenge the constitution of a statute, you are done. That issue will not be addressed at the appellate level or at the trial court level. And so there are procedural shields in addition to the fact that standing is not law. It's a legal doctrine, and that we have a right to reform government, and we have a right to apply to government, including the courts. And so this bill itself, in my strong opinion, is in violation of our state constitution because it oppresses the right to apply to those invested with the powers of government, and it oppresses the right to reform government. And it oppresses the right to bring suits against the state in Section 17. Thank you for that question, Representative Johnson.
Representative Johnson, any follow-up?
Oh, no, I'm good. Thank you.
All right, thank you. Representative Scarborough, you're recognized.
Move to go back into session.
Second.
All right, members, we'll go back in session. And so I have Representative Travis, you're recognized. Thank you very much, gentlemen, both of y'all for being here present. Thank you very much.
Thank you, Madam Chair. I'll call previous question.
All right, members, we're voting on, Madam, can you open the board for a previous question? We're going to need to vote on that, please. All those in favor of previous question, vote aye. Those opposed, vote no. Anybody want to change their vote? Madam Clerk, can you please call the vote?
Madam Chair, you have 13 ayes, 7 noes, and 0 present not voting.
All right, previous question fails. Representative Todd, you're recognized.
Thank you, Madam Chair, and I appreciate the testimony we had, and I appreciate a lot of the conversation we've had back and forth with a lot of good folks in this argument. We've got some very strong conservatives on one side of this issue, and we've got strong conservatives on the other side of this issue that I trust. So this has really put me in a tough spot to try to dig into details for something that is very difficult for me to understand since I'm not in that world every day like some of our folks. But I have learned that as the testimony brought out a minute ago, the interpretation is the issue. The law was passed in 2018 after 222 years of this state existing and not having any problem whatsoever in this realm. That's what's baffling to me, and no one has been able to come to me with a legitimate answer of why that was a problem. And they weren't bringing this issue of a constitutionality to this General Assembly to fix. The issue that was brought for some licensing agencies in this state has now been judge developed.
as the gentleman used a while ago. The judges have developed this interpretation around government actions, what that means, and around affected persons. And that's really the crux of this. And this bill, I believe, narrows that back down to what it should be and what it was for 222 years when nobody had a problem. And I think that's what we need to go back to. And I appreciate all folks contributing to this argument, bringing us information and sharing with us as members and bringing their issues. You have literally brought your issues to the General Assembly, and we are dealing with those. That is what the Constitution says, that you may petition your legislators, and you have done that. And I appreciate the process. So thank you for everybody that's been involved in this.
Any follow-up? All right, thank you. All right, Representative Johnson, you're recognized.
Thank you, Madam Chair. This is an odd one as well as my colleague just spoke about. I've heard from all sides of the aisle, but I can tell you that I got a lot of emails on this issue. And some people will tell you I'm a Republican or I'm a Democrat or I'm an independent. But I don't think I got a single person that wanted a yes vote on this bill. They were all very concerned about it. And regardless of the party, everyone who emailed me on this legislation were against it. And so I'm going to have to vote with my constituents on this bill. Thank you.
Representative Bolso, you're recognized.
Thank you, Madam Chair. Members, let me try to be somewhat helpful in distilling what I see the issue to be, because I've been involved to this point in 3 litigated matters that involve this very statute, 1-3-121, 2 of which are still pending, one against the local government, one against a state official in her official capacity. And what Chairman Todd says is correct, that for 222 years, we did not have this statute, 1-3-121, but nevertheless, there were means by which citizens could raise and challenge the constitutionality of statutes. You heard from General Rice that prior to 2018 was done pursuant to this Colonial Pipeline case, which is a state equivalent of a federal case called Ex parte Young, which allows you to sue a state official to enjoin prospectively the enforcement of a statute that is alleged to be unconstitutional. And the reason you could do that was because there's no sovereign immunity that attaches to a public official enforcing an unconstitutional law. The law is very clear about that. But what happened in 2018 is that this body passed this statute, 1-3-121, and it said, regardless of any other law, a cause of action exists in favor of an affected person to challenge the legality or constitutionality of any governmental action, which includes a statute. And our Tennessee Supreme Court in 2022 interpreted 1-3-121 to be a waiver, an intentional and clear waiver of sovereign immunity. So that what happens in court now is that when a party has to sue the state or a political subdivision, you bring the action pursuant to 1-3-121 because it takes away this defense of sovereign immunity, which is one of the principal defenses that the state would raise in defense of an action regarding legality or constitutionality. And in the cases that I've been involved with, I mean, we've been successful every time in defeating arguments about standing and sovereign immunity because we had 1-3-121. So if we adopt HB 1971 and we take it away, will citizens still be able to sue the government over legality and constitutionality of statutes? Yes. Will it be more difficult? Yes, it will be. It'll be back to the standards that we had before 2018. So in summary, if you're someone who believes that the General Assembly went too far in waiving sovereign immunity in 2018, and you want to make it more difficult for citizens to sue the state government, not the local governments, they're exempted out of this recapture of waiver of sovereign immunity. But if you want to make it more difficult for citizens to sue the government, then you probably want to vote in favor of this bill. But if you're someone who does not want to give back that sovereign immunity, if you're someone who wants the people of Tennessee to retain the rights that they obtained when this body adopted the statute in 2018, then you're going to want to vote against this. But this is clearly something under our Constitution, Article 1, Section 17, that rests with this body. It's the General Assembly under the Constitution that has the authority to waive sovereign immunity if and when it wants to. This body chose to do that in 2018. It can take it back in 2026 if it wants to. The question is, do you want to do it? Do you want to do that? Do you want to make it more difficult for citizens to sue the state government? Or do you want to keep the rights in place? That, to me, ladies and gentlemen, is what it comes down to. And for my part, I like the statute as it is right now. I think it's difficult for me to take rights away from Tennesseans once we've granted those rights. And we definitely granted those rights in 2018 when we adopted 1-3-121. Thank you, Madam Chair.
Thank you. Sponsor, you're recognized.
Thank you, Madam Chair. And I as I was listening to Chairman Bolsa, who I have the tremendous amount of respect for, I understand that if we made it much easier to sue the state of Tennessee in 2018 because we allowed people to come and bring lawsuits based on policy and not legal arguments, based off policy, not actual harm. We are the only state in this country that allows for folks to bring lawsuits against the state based off policy and not actual harm. So I thought it was important to make that point that right now, if you just disagree with what we do here as a body, you can file suit. You don't have to show any sort of harm, just like you do in any other cause of action that we have in tort. I mean, you have to have harm to be able to bring a lawsuit, to have standing to bring a lawsuit. And right now, if you just disagree with what has been done here, you can bring a lawsuit. And that's not how we should operate. You should have to show and prove your cause of action before you bring it. So I just wanted members to know that. Thank you.
Leader Lamberth, you're recognized.
Thank you, Madam Chair Lady. And to follow up on the chairman's comments there, I mean, we were both here and voted for that bill. And I remember when it came through the legislature, it was intended to open up a small crack in the law to allow for some nuanced positions to be challenged in court. It was not meant to blow an entire hole in the side of the state's process on how it is sued. And so now every frivolous lawsuit that anybody can dream up is being filed against the state with millions of dollars in discovery over policy discussions that happen right here in this committee and should be happening in the legislative branch. The courts have extended this well beyond anything the legislature intended. And I say that as someone who, again, voted in favor of the original bill. For 222 years, as my friend the chairman has mentioned, you could sue the state of Tennessee. You could sue it in the intervening time from 18 till now, and you'll be able to sue it afterwards. And if you have a meritorious claim, it will be taken up. Will it look a little different? Absolutely. Will there be a pathway there that talented lawyers can still take before, like my friend from Williamson County will be able to? He's got multiple lawsuits pending now, and I'm sure many more that are being cooked up at this moment. And that's perfectly fine. But the courts have taken this way beyond anything the legislature ever intended. And I don't approve of that. I respect the judicial branch. I wish they would respect more the words that were on the page when we passed this, because they've interpreted this well beyond where we intended for this to go. And so no other state's done this for a reason. And a very wise friend of mine says that if you're the only state doing something, you are either leading the pack and others will start emulating you, or you've made a terrible mistake if nobody else does, because you probably have passed something that doesn't work very well for the people of this state. And the last thing I'll say on this, the millions of dollars that are being spent on litigation on this are being paid for by the citizens of this state. That's who's paying for the discovery. That's who's paying for the defense of the laws that we pass here. And both sides of the aisle have brought that up on many different occasions. Why should we make it so easy to bring a frivolous lawsuit that could easily be taken up through amendments in the law and be debated in this chamber, and make it so easy to sue the state of Tennessee over a policy difference that we're costing the taxpayer millions of dollars? And again, not over legal issues, but over policy debates that should happen here in this body. So I certainly support the bill. I think we are arguing about some very very fine distinctions in the law, and I enjoyed the back and forth between two fine lawyers that I respect both of a while ago. It's fun to watch y'all argue with each other, but we're grinding this down into, very, very fine grains of sand on the differences here. I just want to reel back a little bit of the hole we blew in the side of the legal framework in our state so that every single citizen can still sue, just like they could before, on constitutional issues, but they can't bring frivolous lawsuits just to dive into the work of the legislature, which should be done here instead of in a courtroom. Those are just my thoughts on it.
Representative Travis, you're recognized.
Thank you, Madam Chairman. I move previous question.
Second.
Any objections to the call of the question? All right, Madam Clerk, open the board. We're going to vote on House Bill 1971 as amended, moving forward to calendar and rules. Anyone wish to change their vote? Madam Clerk, count the vote, please.
Madam Chair, you have 11 ayes, 9 noes, and 0 present not voting.
All right, we have House Bill 1971 passes. It's moving forward to calendar and rules. All right. Hold on just a minute, members. We're going to. Which item number are we going to? Sure.
See the wheels turning right now. He's like, you change it, I'll still be able to see. Gino will find a way.
All right, members, we're going to go to item number 56, House Bill 2154 by Representative Raper.
Motion. Second.
Chairman, I see that you have an amendment on this one. 013691.
That's correct.
Motion on the amendment.
I have a motion and a second. All in favor of adding amendment 013691 to House Bill 2154, please say aye. Aye. All those opposed say no. All right, sir, your amendment's been added to your bill. You're recognized to tell us more about your bill.
Thank you, Madam Chair and committee. This bill requires court-appointed guardian ad litem in divorce cases involving minor children to complete appropriate training by a qualified professional, which we know that this will be done by attorneys, and several of those are already qualified. And we're talking about qualifying in 3 areas: early childhood development, child development, and adolescent development. This testing will be done virtually. Hearing that it's about 1 hour for each session. It's at no cost to an attorney, and some of them already have completed going into, some have completed part of it. But what this bill actually does is, from this point on, that it will give you 3 years to complete any of the 3 areas of training, and that's all it did. Just get latitude to them. Thank you.
All right, members, do we have any questions? Representative Johnson, you're recognized.
Thanks. Just a quick one. I think I might have talked about this in subcommittee, but why are we allowing 3 years for that training? It seems like it's not that many hours of training, and I would hope that we would require them to get it done sooner than 3 years after being active as a GAL.
Thank you for the question. This is just giving more latitude on the plate. When you're talking about the plate of an attorney, it is busy, and we all realize that. Well, this just gives them 3 years to where, if they didn't complete it, then a judge actually at this point could not actually, unless they just check for it, they actually can't give them the latitude of being guardian ad litem. So this just gives privy more to attorneys.
Representative Garrett, you're recognized.
Thank you, Madam Chairman, just in the regards to my friend from Knox County, if we had a shortened period of time, we might not have a guardian ad litem. It's difficult sometimes to have many that can be available to take on this role. So I think the idea here is probably to provide a little bit of runway for folks so we don't prevent folks from serving in this capacity. That's a very important role to take on. Is that somewhat you're concerned about, to make sure we have a long runway to get these folks trained?
Sponsor, you're recognized.
Thank you, Madam Chair. That's correct. That's exactly what we're trying to do. Just give our attorneys more latitude, a longer runway, as you said.
All right, members, any more questions? All right, are we ready to vote? Madam Clerk, open the board. All those in favor of sending House Bill 2154 as amended to calendar and rules, vote aye. Those opposed, vote no. Anyone wish to change their vote? Madam Clerk, please count the vote.
Madam Chair, you have 18 ayes, 0 noes, and 0 present not voting.
All right. House Bill 2154 as amended moves to calendar and rules.
Thank you, Chair and Committee.
Thank you. All right, members, let's go to item number 67, House Bill 2567 by Chairman Kumar. Chairman, I'm also showing an amendment on that, 015718. Do you wish to proceed with that amendment?
Yes, that is correct. Thank you.
All those in favor of adding 015718 to House Bill 2567, say aye. Aye. Those opposed, say no. Your amendment's added. You're recognized, sir.
Thank you. Members and Madam Chair, this is a cleanup bill to Chapter 520 that we passed in 2025. That was also known as Savannah's Law, and it was for repeat domestic offender registry, domestic violence offender registry. As the law has taken effect, the results have been very positive. Between 9 to 10 states have called us. They wanted to do a similar law because ours was the first in the country. But during the implementation, certain recommendations have come through TBI and other courts that have made some recommendations, and we are incorporating those recommendations into this bill. Those features include clarification on convictions that constitute a defendant being placed on the registry, and important questions such as, does a previous non-domestic felony count towards the number of offenses made? Clarifications about specific time period a defendant will be placed on registry, convictions in other states, do they also count or not, and make various changes to the documentation that the court clerks have to send to the TBI. List of those changes is within the bill itself, and I'll be happy to answer any questions.
Thank you, Chairman Kumar. Members, any questions for the sponsor? Any objections to the question? Seeing none, members, looks like we're going to be voting. Madam Clerk, to open the board. Vote and send House Bill 2567 as amended to Finance, Ways, and Means. All those in favor vote aye. Opposed vote no. Has every member voted? Any members change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 2567 as amended is moving to Finance, Ways, and Means. And also, Dr. Kumar, you have item 68, House Bill 2574. And you have a motion and a second. I'm looking at House Amendment 15606. You got a motion and a second. Would you like to move forward with that, sir?
Yes, sir.
Very good, members. Any objection to hearing that motion or that amendment? All right, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chair. Also, last year, we passed a bill clarifying the matter of when a a person with a DUI charge is resistant to giving their blood sample. And the previous law was that law enforcement can use reasonable force to restrain them and be able to draw the blood. In this day and age, that's not a good idea in the sense that what is reasonable force is difficult to define and problems can happen. So the law enforcement requested that instead of restraining a person and depending on law enforcement to restrain him in a reasonable way, what we will do is that if implied consent is not obeyed, then a person's license instead of 12 months will be suspended for 18 months. When we did that and the bill did pass, however, it applies to a collection of blood samples. We forgot to include that it should also applies to breath testing, and this bill adds that feature also. With that, I'll be happy to answer any questions.
Very good, members. You've heard from our sponsor. Any questions? Seeing none, any objection on the question? Seeing none, Madam Clerk, you open the board. Members will be voting to send House Bill 2574 as amended, Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Sir, member voted. Any member, let's change the vote. Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 3 noes, and 1 present not voting.
Very good. House Bill 2574 as amended is moving to Finance, Ways and Means.
Thank you, Mr. Chairman and committee.
All right, and moving down, item 73, House Bill 1678, Representative Sparks. And I'm not seeing any amendments, sir. And you're probably recognized.
Thank you. Thank you, members. Members, House Bill 1678 present laws that prohibits a person from knowingly taking, sending, or otherwise causing to be taken any weapon, ammunition, or explosive, any intoxicant, drug, controlled substance, or controlled substance analog, any telecommunication device into a penal institution where prisoners are held, possession of those items with unlawful intent without the express written consent of the chief administrator of such penal institution is also prohibited. This bill generally makes it a Class C felony to knowingly take or send any weapon, ammunition, or explosive device in a penal institution, or to possess with unlawful intent a weapon, ammunition, or explosive into a penal institution. A Class C felony is punishable by imprisonment up to of 3 to 15 years and a fine up to $10,000. However, if such action results in the death of another person, this bill makes it a Class B felony, which is punishable by imprisonment of 8 to 30 years and up to $25,000. This bill generally makes it a Class D felony to knowingly take or send any intoxicant, drug, or controlled substance analog, telecommunication device in a penal institution where prisoners are held, possession with unlawful intent of any intoxicant or controlled substance is also generally a Class D felony. Class D felony is imprisonment of 12 years and a fine of $5,000. However, such actions result in the death of another person makes it a Class C felony. This bill generally makes it a Class E felony to possess telecommunication device with unlawful intent and without permission in such penal institution where prisoners are held. The first violation is punishable by a fine. Second, subsequent violation is punishable by a fine of $3,000. With that, Chairman, I'll open up for any questions.
Very good, members. You've heard the explanation. Any questions? Representative Johnson, you're recognized.
Thank you. I just wanted to know what the change is. How does that change? What is it currently, the charge?
It's strengthened the law, ma'am, from Class C felony to a Class B felony, which results in the death of another person, another inmate.
Thank you.
Thank you, ma'am.
Members, any additional questions for the sponsor? All right, seeing none. Any objection to the question? All right, seeing none. Madam Clerk, you open the board. Members, we voted to send House Bill 1678 to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has everyone voted? Any members change the vote? All right, Madam Clerk, take a vote.
Mr. Chair, you have 16 ayes, 2 noes, 2 present not voting.
Very good. Members, House Bill 1678 is moving to Finance, Ways and Means.
Thank you, members. Thank you, members.
And if we could move to item 81, that's Representative Stevens. That's House Bill 1521. We got a motion and a second, and I'm not seeing any amendments on this legislation. You're probably recognized.
Thank you, Mr. Chairman. This bill deals with hit and run accidents that involve injury or death to a person. Right now, it's a Class A misdemeanor to leave the scene of an accident where there's an injury. This would increase that to a Class E felony. And then if there's a death involved and the person that causes the accident and runs knows or reasonably should know that the other person died, it becomes a Class D felony. And I believe we have some testimony here today about this bill, Mr. Chairman.
We do. Members, any objection going on in the session? All right, seeing none. All right. And Representative Stevens, I don't have the names on my list, so would you just go ahead and call the folks out? And
It's Kim Webb and then William Anderson.
Very good. Ms. Webb and Mr. Anderson. Okay, very good. Yeah, just come up there and have a seat. You both will have 2 minutes each. The red light will come on the microphone when it's live. If you'll just introduce yourself, and then you'll have 2 minutes. And so, ma'am, if Ms. Anderson, if you go, then Mr. Webb, you can go next. So, please. All right, you're recognized.
Thank you. Chairman, members of the committee, this issue is not complicated. It is predictable. Drivers who leave the scene are not acting randomly. They are responding to incentives. Across the country, case patterns show the same thing. When the penalty for fleeing is equal to or less than the penalty for staying, people flee. Not all, of course, but enough to matter. And in fatal hit and run cases, the incentive becomes even clearer. No sobriety test, no immediate accountability, and time to distance themselves from the scene. That is not speculation. That is how these cases unfold over and over again. So when we hear concerns that stronger penalties are too harsh or won't change behavior, we need to be honest about what the current system is already doing. Right now, our law creates a perverse incentive structure: stay and face certainty, run and create doubt. And in criminal behavior, doubt is leverage. This bill is not about punishment. It is about alignment, because laws are not just reactive, they are instructive. If the consequence for fleeing is not clearly greater than the consequence for staying, we are, in effect, giving permission, not in words, but in structure. Whatever panic or fear someone feels in the moment, it does not justify leaving the scene. The law must address that choice, because the most critical window for survival is often the first few minutes after impact. Fleeing the scene doesn't just avoid responsibility, it can turn injury into death. This is about restoring a basic expectation. If you hit someone, you stop, you call for help, you face what you've done. Not later, not after 29 hours, which was the case with the defendant where my son died. Immediately. My son Jimmy didn't get that chance, but this bill ensures that more people will, not by hoping for better behavior, but by structuring for it. That's what good law does. Thank you.
Very good. And thank you for that. Ma'am, what was your name one more time?
I'm sorry, I'm Kim Webb.
Kim Webb. Okay. Sir, go ahead. And if you introduce yourself, and you'll have 2 minutes.
My name is William Anderson. I've been asked to read a statement from Ian Gray, the safety chair for the Harpeth Bicycle Club in Williamson County. Chairman and committee, we come today before you with a heavy heart and clear purpose to support James Bradley Life Protection Act, known to many Tennesseans as Jimmy's Law. Our state's roads are not just asphalt and painted lines, they are arteries of our community and routes Tennesseans take to work, to school, to family dinners, and to the people and places they love. When someone is killed on these roads, it is not only a tragic accident, it's a rupture in a family and in a community and in a future that will never unfold. Under current Tennessee law, when a driver strikes a vulnerable road user, a motorcyclist, a cyclist, a pedestrian, and then flees the scene, the penalties often fail to reflect the gravity of the harm caused if these victims die. There is no separate offense that distinctly accounts the loss of life. There is no mandatory minimum that removes ambiguity, and in effect, the law does not sufficiently distinguish between leaving a scene and taking a life. That must change. Jimmy's Law would recognize fatal hit and run crashes as grave offenses as they are. It would establish a mandatory minimum sentence for drivers who flee when injured or death has occurred. It would strengthen the penalties in preparation of irreversible harm, and it would close a loophole in that today's risky, incentivizing flight in responsibility. For many of us, this issue is not abstract. Across Middle Tennessee, including Williamson County and the rural roads surrounding Leapers Fork, we are seeing increased speeds and increasingly aggressive driving behavior. Cyclists and pedestrians remain among the most vulnerable users of our roadway. Recently, our broader community mourned the loss of Blaze Schaefer, a friend, fellow cyclist, and a Tennessean whose life mattered deeply. His killer is still at large. Within our cycling community, we respond with action. We have built safety standards. We train our ride leaders. We document incidents. We hold our members accountable. No one from our club has died yet, but we ride knowing the risk is real and growing. Jimmy's Law strengthens accountability after tragedy, and that is essential. As this legislation moves forward, we also respectively encourage that the educational component associated with this bill be leveraged, be reinforced driver awareness of Tennessee's vulnerable road users. Education about legal consequences is critical, but education about
All right, sorry, I'm sorry that I've let you go over about a minute in addition to, and I apologize. I was trying to get you to read that whole statement. Without objection, we'll go back into session. Leader Lambert, you recognized.
Move previous question.
Previous question been called. Is there any objection? Seeing none, members are going to be voting to send House Bill 1521 to Finance, Ways, and Means. All those in favor, vote aye. Opposed, vote no. Madam Clerk, you open the board. Does there member voted? Any member wish to change the vote? All right, very good. Madam Clerk, take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 1521 is moved into Finance, Ways, and Means. Congratulations.
Thank you.
Appreciate you all being here. Thank you so much. Members, without objection, we'll roll all remaining bills till next week, and we'll stand adjourned.